Hello and welcome back to my basic mock trial overview. Today we're going to be talking about basic hearsay exceptions and objections. If you're interested in more detail about hearsay, I have more advanced videos that walk through more nuanced looks at what hearsay is and what hearsay isn't and how the objections function. But if you just want a quick once over, this will get you everything that you need to know. First of all, what is hearsay? We have what's called in the legal concept a declarant. A declarant is the person who is making the statement. The declarant is normally the person who has firsthand knowledge of whatever they're testifying about, i.e., the person who sensed it, who touched it, who heard it, who saw it, so on and so forth. If the declarant is not available to testify, then it becomes hearsay by nature to testify about what they said. So hearsay is an out-of-court statement offered to prove the truth of the matter in dispute. I have an easy example here. Let's say that we had a defendant who was on trial for theft, and that defendant wanted to testify that someone told them that they could take whatever item they had allegedly stolen. Well, that goes right to the heart of the question in the case, because the whole case is over whether or not the defendant had consent to take the item. So allowing them to testify that someone else who isn't in the courtroom told them that they had permission is inadmissible hearsay. I have a few more examples here, and if you kind of look at the hearsay column, what you'll notice in each case is we have a declarant who is not present, testifying about something that is the heart of the matter that we talk about in the case. It's the truth of the matter asserted. So not every out-of-court statement is necessarily hearsay if it's about something that doesn't get to the question that the jury needs to answer. I think this is easiest to understand if we look at the non-hearsay column. For example, in any criminal case, the police officer is usually going to get a call from dispatch that tells him or her to go to the scene of the crime. Police officers are rarely there when the crime happens. It does happen, but it's pretty rare. Normally, police officers receive a call on their radios and they go to the place where the crime has allegedly been committed. That being said, we don't pull in the dispatch officer. We allow the police officer to testify as to why they went to the scene of the crime, because that has nothing to do with whether or not a crime was committed. And some of the rest of these are exceptions that we'll get into in just a moment. But just remember, if it's not about the matter at heart, if it's not about the truth of the matter asserted in the case itself, then while it is hearsay, it's still admissible. There's a lot of exceptions to hearsay rules. I'm only going to go through the three basics in this case: excited utterance, records of regularly reported activity, and present sense impression. All of these are available if you want to see the actual rules. The easiest to look at are the federal rules of evidence. So if you look online and search for Federal Rule of Evidence 803, so Federal Rule 803, that's the hearsay rule with all the hearsay exceptions. So if you'd like more information, check that out. But I'm going to walk through each of these right now. The first is excited utterance. Excited utterance has two components to it. It has to be a startling experience and a spontaneous reaction. This doesn't happen very frequently in courtrooms, but it's really those situations where you have, I almost call it like a bang-bang play in football or in any other sort of contact sport, where something happens and immediately someone reacts. Oh, there's been an injury, and you react to it and you say something very quickly. Those, the court believes, are not likely to be false. Those are likely to be true statements because you're seeing it and you're saying it in the moment. And so I have some examples up there that talks about how these sort of spontaneous reactions to incidents can be admissible hearsay, even if you don't have the person who made that statement. This is a ruling the court would usually make before trial, but it can come up during trial as well. The most common exception to hearsay is what we call regularly recorded activities. There are tons of things in the court systems when we do not bring in the person who wrote down the actual recorded activity. We allow someone else to testify for it. Police reports, weather reports, marriage, death, birth certificates, medical records. Technically, if you think about a marriage certificate, you would have to get the clerk from the municipal office to come in and testify that at X day, two people came before them, they paid the fee, this is what they said, and then they issued the marriage certificate. We do not, in the court system, generally make people do that. If it's a regularly recorded activity, we allow someone else to testify to the truth of that because those activities are normally very trustworthy. Sort of the overarching idea here with hearsay exceptions are, is the statement, even though the declarant is not available and it's therefore hearsay, is the statement normally truthful and reliable? That's the standard that the court is going to look at. And it's very true with the last one as well. And that's present sense impressions. In terms of actual witness testimony, a present sense impression is probably the most likely exception to hearsay that you will see. Normally, these are things, just like with the excited utterance, these are statements that are made while the event is unfolding, and they're usually describing or explaining the circumstance. I have some examples up there. The key example would probably be explaining that the shooter, the person who has allegedly committed the crime, was present at the time of the crime because this person saw them, shots were fired, and it was immediately during or right after the event that they made that statement. That makes it a present sense impression. All right. So a lot of this has to do with time. If it's very soon after the incident, it's much more likely that the court is going to deem that reliable. If the statement is made hours after the incident, even though it may be describing or explaining something that the witness saw, the court is likely to rule that unless the declarant can come in and testify about that and be subject to cross-examination, that does not meet the hearsay exception. So those are just a few basics about hearsay. It's a much more complicated topic than that. And if you're interested, I have other videos on the topic that you can watch. However, the best way to understand hearsay and hearsay's exceptions is simply by practice. Practice will make you a better mock trial attorney in evaluating what is going to fly as hearsay and what is going to be a sustained objection.